Probably the first question that anybody asks about a DWI received in North Carolina is, can I fight the charge? Fighting a DWI depends on the presence, first of all, of the state's elements to proving a DWI, as well as the possible defenses we can raise on our end to the DWI charge. The elements of a DWI are that somebody is driving a vehicle on a public highway while impaired. The state typically is looking at the while impaired prong as their most difficult element to establish. They can show that you're impaired by two methods. The first is by what is called per se intoxication laws. In North Carolina, the legal limit is a .08. If the state introduces a chemical test, whether blood or breath, of impairment above a .08, then that is in and of itself enough to show that you were impaired. If they're not able to show, introduce the chemical test, whether it's because we have suppressed that test from coming into evidence or there is not a chemical test that was performed, then they have to show that the person driving was what's called appreciably impaired. And they can do this by showing that a person has failed standardized field sobriety tests, the officer's sense impressions, so the smell of alcohol on your breath, bloodshot eyes, staggering on your feet, having problems performing any of the tests that they're asking you to perform, any type of poor driving. Those are all ways for the state to prove that you're appreciably impaired, and it's normally a collection of those items that would be used to establish that appreciably impaired prong, as opposed to one particular standardized field sobriety test being performed or one particular element. We then look at possibly raising defenses to the DWI charge. There can be issues with the stop, constitutional issues with the stop itself, constitutional issues with the officer having probable cause to have arrested you in the first place, as well as problems back at the station or at the jail with the intoxilizer. Was the intoxilizer performed correctly? Were you given read your rights as far as the right to refuse the chemical test being performed at the station? Also, post-release issues. How long did it take for you to be released? Were the conditions of your release adequately explained to you, and were you released at the earliest opportune time? These can all be issues that we can raise to defend your case. I'm going to go through that one more time. So are we still good at kind of that whole section? One of the first things that we look into after sitting down with you in regard to your DWI is what defenses can we present on your behalf. In our analysis, we look first of all at the state's elements that they have to prove to show impaired driving, as well as our defenses to the DWI charge. The elements of a DWI that a state must show beyond a reasonable doubt are that a person is driving on a public highway in a vehicle while impaired. And it's typically the while impaired prong that is the problem for the state, although the other elements must be established beyond a reasonable doubt, and we will look into whether or not we can present possible defenses on that angle. If in fact that they are proceeding on the impaired prong, that being the most difficult on their end to show, there are two ways that they can show impairment. In North Carolina, we are a per se intoxication state, which means that if there is a chemical test, blood or breath, that shows a .08 or above blood alcohol concentration, that in and of itself establishes impairment if the state introduces that into evidence, and that is heard by the trier of fact, whether that is a judge or a jury. The other way that the state can prove impairment is by showing that a person is appreciably impaired, and the state or defense district attorney will typically pull out of the officer poor driving, sense impressions of the officer. So if there was a smell of alcohol, bloodshot eyes, staggering, slurred speech, all of that would be presented by the state. Finally, they look at chemical tests, or non-chemical tests that were performed by the officer, standardized field sobriety test, These can include what is called the horizontal gaze nystagmus test, or finger-to-eye test, where there's an eye check that is performed by the officer, a walk and turn test where you would take 9 steps down and turn and take 9 steps back, as well as a one-leg stand test. These would be taken in combination to show appreciable impairment. So one incident of poor driving or one standardized field sobriety test in and of itself would very likely not be enough to establish appreciable impairment. We'd also look into potential defenses that we could raise, including the lack of the officer to have reasonable suspicion to stop you in the first place, that the officer did not have the right to pull you over, probable cause to have arrested you if there's an issue with the officer not having enough to have placed you under arrest and take you back to the station. If there was not enough evidence of impairment there at the roadside, then you cannot be arrested for impaired driving. And then we'll look into procedural issues that would have occurred at the actual jail, those including issues with the chemical analysis being performed, issues with the intoxilizer itself, as well as issues related to release. You have to be released as quickly really as possible in a DWI case, and we'll look into those issues as well.